Good afternoon. Thank you for joining us for today's episode of That Biz Law. For that title, we have a little bit of a unusual topic to cover today. My name is Joe Whitcomb. I'm president and founder of Whitcomb Selinsky PC, a law firm situated in the South Metro section of Denver, Colorado. And with me, I have Brandon Selinsky, the Selinsky in our name, another of the other named shareholder in our law firm. Over the next 15 minutes or so, what Brandon and I plan to talk about is just some intellectual property issues. And Brandon has a particular interest in working in the trademark space with brewers in particular, and he's already started doing some of that in Denver, Colorado. So welcome, Denver. Welcome, Brandon.
Thanks, Joe.
Brandon, first do a little bit of an introduction. You, like me, were not born in Denver, Colorado.
I am originally from Northville, Michigan. I came out to Denver about 16 years ago, and I had gone to law school in Nebraska and finally made my way out west to Denver by about 2005, maybe. So as Joe said, I'm the Selinsky in the Whitcomb Selinsky. My practice is generally focused around administrative law, which includes Social Security and VA disability and any other kind of administrative practice or administrative work that we do. I also do trademark law. And I got into trademark law by working with breweries and trying to figure out what their needs were and how we could serve them. And one of the biggest things, most immediate things that a lot of breweries need is help with trademarks.
So let me stop you there. I'm a brewer. I'm situated here in Denver, Colorado. Are there many breweries in the Denver metro area?
Short answer is yes. There are about 300 breweries in Colorado now. I think it's a little better than that.
So it's a competitive space, then.
It's a competitive space, and there are more breweries almost every day.
But if I'm a brewery in Denver, Colorado, and I have, it's called a tap room, right? So I have a place that I brew beer.
That's right.
Why do I care, in particular, about trademark?
Well, first of all, since you brought it up, a tap room is a specific term. A tap room or tasting room, that's where you sell your beer. If you make beer and make it only, you're not selling it in your space, then you have a manufacturing plant, and that's a difference in Colorado. Those are different licenses. So let's say you have a tap room, and you're selling your beer, you're making your beer, you're moving it over to the tasting room side, and then you're selling it. For each of those beers needs to have a name. Each of those, so that each beer needs to have a name. Your brewery needs a name. You might have names or logos for other elements of what you do as a brewer. And so every time you come up with a new beer, you need a new name. And that name can't be the same name as any other beer. If it is, then you might run afoul of somebody else's trademark.
So I got a question for you. If I want to branch out from the legal business, I'm going to start a brewery here in Denver, Colorado, and because I'm sort of a self-important gentleman, I decided I want to call that brewery Whitcomb Brew. Should I run right out and trademark Whitcomb Brew?
Well, you can, but you can't trademark it like you think you can. There are two.
How do I think I can?
You think that you can run out to the USPTO and register your trademark, and you can for a lot of different things. But the specific trademark that you have suggested here, Whitcomb Brew, that can't be trademarked on the regular, what they call the principal register of the USPTO. The USPTO is the United States Patent and Trademark Office.
Is that because somebody already owns Whitcomb Brew?
No, that's because anybody named Whitcomb can use the name Whitcomb Brew. So the PTO wants to make available surnames. If you use your last name in brewery or beer works or whatever it is, the PTO will not let you register it because the idea is there are other people with your last name. They ought to be able to use their name. And so absent some extra showing, you can't register your last name. However, you could go to the supplemental register. You could register it there. So you could put Whitcomb Brew on the supplemental register. And then after 5 years, if you're still in business, and hopefully you are, you can roll that over to the principal register.
All right, well, when I was growing up, a lot of people would confuse my name and call me White Comb. So what if I wanted to be creative and call it White Space Comb, C-O-M-B, Brewery?
You can do that.
What about is there a problem with using the word white and trademarking the word white?
If you trademark that entire name, White Comb Brewery, you may have to disclaim part of that. You don't have the exclusive right to the word white. You don't have the exclusive right to the word comb.
Seems like I could own the word white. Why can't I own the word white? Seems like the guys that made my iPad, they own a piece of fruit, don't they? They own Apple.
That's right. They do. They own Apple because they're using Apple in a way that, that no one before them has used. The word Apple doesn't really apply. It doesn't relate to electronics at all.
It does now.
It does now, yes. Before they started, it didn't. So you may have to disclaim part of it. And really, in your example, you probably would have to disclaim the word brewery. White and comb, you might not have to disclaim, but the word brewery you would have to, because you are a brewery, and
Well,
that would be descriptive.
People don't typically think of beer when they think of a white comb, right?
That's right, they don't. Until your beer comes around and makes that connection, just like Apple did.
And it would be an amazing beer.
I'm sure it would be.
So,
Yeah.
even though, disclaimer, I've never ever made a beer not successful. So, but you've made beer.
I have. I've made lots of beer.
So you've been a beer guy. You've been what I like to affectionately know and call a beer nut. You've been a beer, we'll use the word aficionado. You've been a beer
That's
aficionado
nice.
for about how long?
Well, I've been brewing for about 4.5 years, well, about 5 years. But I've been a beer nerd or beer nut for going back to before I was legally allowed to consume beer.
All right, so full disclaimer, if you are with the FBI, the statute of limitations has long since run on Brandon's drinking a beer before he was 21. Do you have a favorite kind of beer or a favorite or beer you stay away from?
I don't generally drink. I'm not going to say in this video that I don't drink IPAs because I don't want to alienate most brewers. I'd rather just talk about what I like. So I tend to gravitate towards big, rich, malty stouts, particularly what people like to call pastry stouts.
Right.
Love those. I don't get to enjoy them very often because at 17 or 18%, it's a little harder to take down one on a school night. But I also, on the other end of that spectrum, I really like nice light beers, particularly funky and fruit-forward beers like sours and things like that.
This is something that Brandon and I, we know, you don't know, but we know we have in common. I am the more pastry, the better on the stout side, so the more things you throw in it, coffee, barrel-aged, super dark. Dark is motor oil, I love that stuff, and I'm a big fan. And the fruitier, and the more sour, the more tart the sours are, I'm a bigger fan. So, you represent a couple of brewers. I know we can't talk about those online because of our non-disclosure agreements and that kind of thing. But what kind of services, besides Trademark, have you afforded any of those brewers?
We have a whole beer law line here at Whitcomb-Solinsky. It's called Beer Law HQ, and we do everything for breweries. And we got into it by taking some trademark cases and then realizing that breweries had other needs. Those needs include real estate contract reviews. They include TTB licensing and state licensing. Everything that you need to do to be able to make beer and then sell your beer, we can help you with that.
Do breweries have any other liability issues?
Plenty. It is a high hazard industry, and so OSHA regularly looks over the shoulder of brewers. They do on-site evaluations, and when you go into one of those evaluations, you need to know what OSHA is going to be looking for and what you need to do to prepare your brewery so that you don't get tagged. We can do that for you.
So we've got a guy here named Tim. Who does some workplace safety issues. He came from the Department of Labor and worked in workplace safety. Is he a guy that you would go to if you found a workplace safety issue?
He's our guy. That's right. He is our OSHA guy. So if you have any questions about OSHA, what they look for, how to avoid getting cited, and what to do if you do get cited, Tim is your guy, and he'll be able to help you through that process so that you come out the other side still making beer and still doing okay.
So I want to go with the trademark thing at a slightly different angle. Let's assume you are, I started White Comb Brewery, and I hired you, Brandon. Hey, do me a favor, man. For money, go register that trademark for me if you can. and lo and behold, you go out and you just go out and register it. What do you got to do?
The process of registering a trademark is before you do anything, before you put that label on a beer, before you put the name on the internet, run it by somebody. Do your research. You want to do a search to see if that name is available. If you do that search and it turns out that 3 other breweries are already using that name, you're probably not going to be able to register it, or if you can, you might get some pushback from one of these breweries, and you'll probably be in a worse position than they are because they're already using it. So step 1, you do a search. You can hire me to do that, or somebody who looks like me, have an attorney do it, or an independent third party do that search and see what turns up. If nothing turns up, great. You go to the next step. But it's important to note that when you do a search, what you're looking for what you are not going to find. You want a clean bill of health. And so if you plug that into Google and nothing comes up, that doesn't mean you have a clean bill of health. There are several other databases. You can use the PTO's own database, TESS. You can use Untapped. You can use a number of other beer databases. But what you really want to know is that there's nothing to know. And so the idea is you have to be very thorough with that search. So if you get past step 1 and you get that search done, you got a clean bill of health, then you go to step 2 and you file the trademark. File the trademark, basically it's advanced paper pushing. You got to fill out a form online and you submit that form to the USPTO. There's a filing fee, and once you do that, then it sits for a while.
Great, then I'm done. I get my trademark filed and I have Whitecomb Brewery.
If only. Whitecomb Brewery, that application will go to the PTO. In about 3 months after you file it, the PTO will put an attorney on it, an attorney examiner, and that person will do their own search, and particularly in their database. They will do an internal search. If a hit comes up, then you'll probably get an office action. So if
that doesn't sound so bad, an office action. It sounds like I get to go to an office.
An office action is done generally in an office, but it's not always that great. And it depends. It runs the gambit. You might get an office action saying, well, there's already Blue Comb Brewery, and Blue Comb Brewery sounds too much like Whitecomb Brewery. It might confuse consumers.
Those 2 things don't sound anything alike. One's white, one's blue. That's clearly different.
That's right. The pattern is the same. So you have a color, you have something to adjust your hair, and then followed by brewery. And the PTO generally runs on the conservative side. If they think that it is likely to confuse consumers, and that's the standard that they use, likelihood of confusion, then they will deny you. But that denial, that initial denial, is temporary. And you have the opportunity to come back and make some arguments and say, blue and white, they're not the same. Maybe it's Blue Brush Brewery. Well, brushes and combs are not the same, blue and white are not the same, and you can make arguments, however technical or not, about how they're wrong. And sometimes the PTO will come back and the attorney examiner will say, you're right, my bad. Those really are not the same. The standard, you meet the standard, and we're going to send you on to the next step. So if that happens, great. About 3 months to get that first response, and then they push you through for the next step. And the next step is publication. So the PTO has a publication that they publish all the new marks in, the new potential marks. So if you register, your mark goes in the publication, and then everyone in the world has the opportunity to look it up and to see if your mark runs afoul of theirs. And that's the whole idea. That publication puts everybody on notice. So if Blue Comb Brewery already exists and they see your publication, Whitecomb Brewery, they can write the USPTO and say, nope, that's too much like our mark. And they can file an opposition. If you get an opposition, that's basically litigation. It's a third party saying that your mark does not qualify as a trademark. So even if the PTO thinks that you're good to go, a third party can write in and oppose it. And there's some limited discovery that can happen in that time. There's a hearing in front of a judge, and there's a verdict. There's a judgment. So that's another possible obstruction, a possible stopping point for your mark. But let's say you get past that. You get published, no one opposes. At that point, the USPTO will write you and let you know, and you'll get a certificate in the mail, and it'll say that you have a registered trademark.
So then I'm good to go. Whitecomb Brewery is now trademarked, and I can forever rest on my laurels knowing that I own that trademark.
Joe, I'm glad you asked that. Of course, no. Trademarks are only as good as long as you use them. So if you file for a trademark, and there are two different kinds, broadly two different kinds that any brewery might want to file. There's what's called a 1A and a 1B. A 1A application means that you're using that mark. You're using it in commerce, meaning you're selling beer under that mark, whether it's the name of your brewery or the name of a beer or another product. A 1B is an intent to use mark, and that means that you have not used it yet in commerce, but you plan to, and you want to get your foot in the door. So you file that 1B application, and if that goes through, then it won't register until you actually use it. So if you get through the publication phase and no one objects to it, no one opposes it, it will sit and wait for you to file another document that says, yes, I'm using it. And you have to re-up that every 6 months. So you have 6 months from the time that they approve it to when you either have to ask for more time or show them that you're show the PTO that you're using it in commerce.
All right, so I have a more serious question. I've got my trademark, I'm using it, and I'm selling billions of dollars worth of beer from my tap room, maybe per decade, but I'm selling lots and lots of beer, lots and lots of folks are using it. And I notice a friend of mine in North Carolina sends me an email and says, hey, you're not going to believe this. I came across your brewery near my home. I didn't realize you had opened up another White Comb brewery near my home in North Carolina. And I scratched my head and I realized that I have not opened a White Comb brewery in North Carolina. What can I do?
You can prevent this new White Comb brewery that's not you from using your mark. If you have a registered trademark and somebody else is trading under your name, you can stop them from doing that.
What if they didn't know? It was an innocent mistake. They just started using White Comb. They didn't do any of the things that you suggested at the beginning. They just hung a sign. They did a Google search, hung a sign, and they haven't tried to register with the PTO. They just registered the trademark, or didn't register the trademark, just started using it. Then what?
In that case, the first thing that you do is you send them a letter. Send them what do they call a C&D or cease and desist letter. You let them know that you have a registered trademark. They are infringing on that trademark, and they need to stop.
But they write you back and they write me back and they're like, Joe, listen, man, I already paid for the signage. I'm already selling beer. Go away.
Don't go away. You need to prevent them from using that mark. If you don't, you can lose your rights to that mark. If you just do nothing at that point, and this new White Comb brewery out east continues to operate, then the value of your mark and the power of your mark is reduced. And let's say a third party uses White Comb brewery and they pop up out west. Now there's the third White Comb brewery. You're going to have a lot tougher time enforcing your mark against this West Coast White Comb brewery because you failed to enforce it against the East Coast one that came along first. So you need to stay on top of your mark and you need to enforce it.
How do I do that, man? I'm selling beer left and right, and I don't have time to stay on the internet and police every corner of the universe to make sure that no one's using White Comb brewery, or what if somebody starts selling White Comb beer? Is that an infringement on my trademark?
So you got two questions there, really, two distinct questions.
You can object if you like.
I won't, I'll just answer them both. The White Comb beer is too much like White Comb brewery. So again, we go back to that standard of consumer confusion. Are consumers likely to think that White Comb beer is from the White Comb brewery? Sure, that's an obvious one. The name is the same, whether it says beer or brewery. That's de minimis, as they say in the legal field. That's not much of a difference. And people are likely to think that those came from the same source. That's what a trademark is. It's an indication of the source of a product or service. If a consumer is confused about what that source is, then you need to enforce your trademark. So going back to your example or your question.
How do I manage that? How do I keep my arms around who's using my trademark?
You have to look, or you need to have somebody who will look.
If you do that, Brandon, do you police those kinds of trademarks?
Well, I do. It just so happens. Yeah, so, and we'll do it periodically. I don't look up every mark every day, but periodically we'll look up marks and make sure that our clients' marks are not being infringed upon. And there are different levels of doing that. So, as I mentioned before, one of the things you can do is just Google it. Throw that into Google, and if something comes up, and these days it probably will. If somebody's operating a brewery somewhere, they're going to have a presence on Google. But an even better resource is Untapped, because it's so immediate and it's so worldwide. If you open a brewery down the street and somebody walks in there and has a beer and they put it right on Untapped, there's a record of it. And there's a record that somebody sold a beer under this name. So use Untapped. Check it out periodically, or have me check it out periodically and make sure that no one is drinking a beer with your name that's not your beer.
Well, Brandon, I thank you for coming all the way from your office, which has to be a good 150 feet away from here.
I brought water.
I appreciate that. That's gonna be it for our broadcast today, but I am gonna ask Brandon back, again, because he works here, but also because the next time we get together, I'd like to talk about some of the other issues that beer or brewers or breweries might run into. But also I want to talk about international trademarks. The next time we get together, I'd like to talk about if White Comb really goes crazy, White Comb beer goes crazy, and I want to start selling that beer in Europe, do I have the ability to trademark it over there? So we'll keep that for suspense for the next time. Again, I thank you all for tuning in to That Is Law. I'm talking to Brandon Selinsky, my partner in law in crime here. Have a great day.